Good morning, everyone. Thank you for being here today. Welcome to our Q&A. I will get started today with our usual housekeeping and instructions. Please remember that we are here not to give legal advice, only to provide general legal information. With that in mind, the chat function is also intended only for questions or requests for clarification, and commentary in the chat is not to be considered legal advice. We'd like to let you know that if you have changes you would like to see made to the Community Association statutes, specifically the WUCIOA statute, you can submit them to the WSCAI Legislative Action Committee. The committee is looking to propose any types of changes during the upcoming legislative session this winter. Please also be advised we are not going to be having the Q&A on July 1 due to the 4th of July holiday. And also, if for whatever reason you submitted a question today and it did not make it into our session, you are free to resubmit it. And today, we will also move to the next session. I'm going to go ahead and get started with the first question here. The first question is, can you charge an administrative processing fee for printing and mailing a notice, as to do otherwise would be using association common funds for the benefit of a single member? The answer to that question is maybe. The answer is different depending on whether you're talking about collection-related notices or notices that are intended for other purposes. Since I'm a collection attorney, I will start with the collection perspective on that. For generally speaking, notices are mailed to the owner in compliance with the statutory requirements in effect as of January 1, 2026. So until an association sends the pre-foreclosure notice that's required in the statute and waits 15 days after sending that notice, delinquent owners can only be assessed the actual cost of printing and mailing the notice, and this must be a reasonable amount. The statute doesn't define what's reasonable, but I think, that's something that's a pretty understandable standard. And also a maximum $10 administrative fee can be assessed to prepare the notice, and a maximum of a late fee of 100 or 5% of the missed late assessment, one assessment, whichever is lower. So that is how any collection-related notices would be handled vis-a-vis the statute that's now in place. Now, there are certainly arguments that could be made about whether notices are for the benefit of the association or for the benefit of the individual owner, if it's a notice related to the assessments and violations. How does your fine and enforcement policy apply? And that may matter as well as to what might be considered a reasonable amount for mailing a notice. For example, you might ask, is it reasonable to assess a fee for a notice when a first violation is only a warning? Is it reasonable to assess a fee in addition to a fine? What if the notice is to comply with a statutory requirement, such as to provide records to an owner? There are many variables here when it comes to non-collection related notices. So that's definitely a question you'll want to ask your association attorney if you are concerned about what is or is not reasonable. Like I said, there is no statutory definition of what's reasonable, but your association attorney can certainly help you understand what may or may not be considered reasonable. Also, the fact that a management company contract may have a fee that they charge for mailing notices does not necessarily mean that the fee can be passed on to the owner. We'd have to look at your governing documents to determine what is and what is not permitted. The client that has that is managed by a management company, the relationship between the client and the management company is not the same thing as the relationship between the client and the owner and their duty to the ownership to act reasonably. So also keep that in mind. Ken, did you want to add anything to that, or Diana?
And you're muted. Tima, could you confirm what the maximum late fee is under the new statute?
So the maximum late fee is $10 or 5% of the late assessment, whichever is lower. So, and it's one missed assessment, not a accumulated missed assessment. You have to look at whether it's a monthly assessment or an annual assessment, whatever, that 5% or $50, whichever is less.
Okay, so the first late fee is the lesser of $50 or 5% of the amount past due.
Correct. And that's only with regard to that initial period, that initial wait period between the time that the pre-foreclosure notice is sent and that 15-day time period.
So in regards to the rest of it, my preference is that if you're going to have a fine for an owner in violation, that any administrative fees be taken out of the fine. So make your fine large enough that you can cover the administrative fees associated with sending notice, rather than sending a fine for $50 or $100 and then also sending an administrative fee for mailing the fine notice. If the purpose of the notices is to get compliance rather than generate revenue, then the association should not be counting on the fine income, and they can use the fine income to offset the expenses for administration of sending out the notices. I might say the same thing about how late fees are calculated. If you've got an actual cost that is incurred because of delinquent assessments, then you could have your late fees be large enough to cover that cost. But I do see some clients look at the late fees as a revenue source rather than an enforcement mechanism. Second question, can an HOA governed by 6438 sell advertising space in a community newsletter? If yes, what are things to consider or keep in mind, as it seems like there could be some inherent liability or concerns in advertising and recommending companies? So we can't find any reason that the association could not charge for advertising space. And yes, there's certainly the potential that owners will perceive that the association is recommending a vendor or service by putting them in the newsletter. So you could make sure that you have, a disclaimer that you are not endorsing or that you're not approving particular vendors. So we don't really see a problem with it in that regard. We would like you to avoid a conflict of interest in, say, providing space for some owners or vendors and not others. So you'd need to be fair in how you allocate the space. And the other thing which a lot of clients don't think about is the income tax that they're going to pay on the revenue. This is true for anything that is not the standard assessments coming in from your owners. So if you've got a cell tower or you rent out your cabana for people not within the community, then that is income which is taxable, and it's often taxed at 30% or more. So you might want to talk to your tax professional to make sure that it's worthwhile to charge for advertising. Anything you want to add, Tina?
I think that answers it, Ken, based on the question, the way it was asked. The third question is in three parts. So I'm going to just go through each part and answer each part individually. So the first part of the question is, if the board wants to hire an attorney to do XYZ, is it considered privileged information to hire an attorney to do something? So no, all attorney-client communications are privileged. So I guess the question is the decision to hire an attorney is not in and of itself a privileged discussion or communication. You would want, if the board is hiring an attorney to represent them, the decision must be made in an open meeting per the WUCIOA meeting requirements in effect. And that is all that needs to happen. Now, the second part of the question is, in an open meeting, would you say, I move to hire John Snow to proceed with the foreclosure on account 123 for $30,000, or do you say something different? So here specifically, the question pertains to authorizing a foreclosure decision. That is a very specific, there are very specific rules and requirements around how that is to take place. I'll just go through some of the specifics here. The amount owed is not specifically required in order to authorize a foreclosure lawsuit, nor is the recommending attorney's name. This is assuming, by the way, that you already have a fee agreement in place with the law firm and the attorney representing you. So sort of going back to the first question, I'm assuming in answering this question that the board has already made a decision in an open meeting to hire an attorney and a law firm to represent them. And now they have a collection file that is advanced to the foreclosure stage, and the board is looking to authorize that foreclosure decision so the attorney can go ahead and draft the complaint and file the lawsuit. So, assuming that's the case, keep in mind that there may be more than one motion. You may have a motion to first send the delinquent owner to an attorney, and then you may later have to authorize a foreclosure lawsuit. So I'm not sure where you are in the process. But in any case, you do not need to state the specific amount that's owed. All that's required to properly authorize a foreclosure decision is that the board must specifically identify the unit or the lot number that's being foreclosed upon. If the board is concerned about confidentiality or perhaps embarrassing the owner, you may refer to either the unit or the lot number or an internal account number or the parcel ID, as long as it is a unique identifying number or account number that can clearly authorize that specific unit or lot. But you don't have to use the owner's name. We actually do have very specific recommended language that personally I provide to my clients when they're asking about how to properly authorize a foreclosure decision and memorialize that in the board minutes, which is required. So what we'll say is that you could put in the meeting minutes and follow the language of, after some discussion, a specific board member, they must be named, move to proceed with the foreclosure lawsuit for the unit, the lot number, the account number, parcel number that gets identified there. And you can say it was recommended by your law firm. Then the motion needs to be seconded by another board member. And then it needs to be noted in the minutes that the board voted in favor of moving forward with the lawsuit, again, against that specific lot number, unit number. And all of that language must be recorded in the meeting minutes. So if you have more questions about that, please reach out to your association attorney. The third part of the question is another example. In an open meeting, let's say I move to hire John Doe to write a letter to the community, John Doe being the attorney. Is it okay to state the attorney's name and what you are hiring them for, or is that considered privileged information? And would you just say attorney instead of the name of the attorney? So again, this is very specific. Again, I want to clarify between the difference about hiring an attorney to do work and the communication between the client and the attorney. The communication between the attorney and the client is always privileged. The attorney's name or the name of the law firm is not privileged. That's a fact. The decision to have an attorney act on behalf of the association is not privileged. However, the specific matter and the details discussed by the board with their attorney is privileged. So, and any decision made upon the attorney's recommendation is the fact that a decision was made is not privileged, but the communication around the decision is. So if, for example, the board is making a decision based on the attorney's recommendation in an open board meeting, that is that is not privileged, but the background discussion is. We do think that it is not a bad idea, that it's best practice, in fact, to indicate the law firm or the attorney that the board wants to hire and to state what the letter, for example, if you're asking them to write a letter, what it's about, the general nature of the letter. Now, it's also important to remember that a legal opinion to the board may differ from the position that the attorney may have based on the board's decision. So I know we're getting into details here, but I'm going to give you an example, which I hope will help illustrate what I'm saying. For example, an attorney cannot give an opinion that an owner is violating all the condominium declaration because of a noise or cigarette smoke or some alleged violation. The attorney can write a letter to an owner saying that the board's conclusion that the board made a decision that the noise or the smoke is a violation of the rules and asking for corrective action by the owner. I think that answers all three parts of the question. Ken or Diana, did you have anything to add here?
To add for me.
So for the second part, which is you were talking about foreclosures, I think it's the legislative intent to make sure that there is a lot of open and transparent discussion before any owner is sent to court for foreclosure. And so that's why the statutes were revised, requiring that the meeting minutes have to reflect the board's decision. You can't just have a policy that says after 90 days, it automatically goes to collections, or at 180 days, it automatically goes to foreclosure, and rely on that policy to approve a foreclosure. It needs to go back to the board of directors, and the board meeting minutes have to reflect, as Tim was saying, that the board considered the issue again and made a decision. It may be that the legislature believes if that's done in an open board meeting, that means more people will know, and the owner who is, otherwise been non-responsive might become responsive. We don't know. It's just that I'm certain there are plenty of people who go to the legislature and they're in the middle of a foreclosure and they claim no one told them that they were delinquent. Now, I don't believe that's true, but there's certainly the possibility it's true. And so the legislature adopts these laws to protect them even more. Otherwise, in terms of the attorney-client privilege, I know a lot of boards are not following what might be required for open meetings and owner comment periods before they're meeting with attorneys. I think we're getting in sort of a gray area, and I just would caution that if you have a group that you think is litigious, you should be more cautious in actually calling a meeting and allow for the owner comment period, and then go into executive session before you have a discussion with the attorney, so that you can make sure you don't get accused of violating the open meeting procedures in the statute. But this is a new statute, which, we just don't know how it's all going to play out, and how attorney-client privilege, which is governed by court rules rather than by the statutes, is going to be something that also gets played out over time. Next question. Can reserve funds be used to pay capital gains tax generated by the invested funds? The amount can be substantial and difficult to predict in advance of the operating budget. So I would suggest you talk with your CPA or tax advisor, but my general rule is that all income that comes from your investments, or from your cell tower leases, or from your owner's assessments, all of it goes into the operating budget first. And if you have taxes to pay, those come out of the operating budget. And if there is a net income, that would be contributed to reserves at the discretion of the board, the same as every other contribution to reserves. Reserve contributions are not automatic. They are a budgeted line item, and there's something which the board can direct to be paid into reserves or not direct be paid into reserves. So if you've got a CD or some other kind of investment that you know is producing taxable income, and you know your tax rate's going to be 30% because it is for many HOAs, then you need to pull the tax out before you deposit the money into reserves. Then you avoid the problem of having to take reserve funds out to pay taxes, which would be a non-reserve expenditure. So uh, I'm sure that this doesn't sound reasonable to some managers because they think that the reserve contribution should automatically go in and all the reserve funds and their income should stay in reserves. But I think from an accounting perspective, that it is income to the association, pull the taxes out first, and then deposit the net into reserves. Anything you want to add, Tima or Diana?
No.
Nope, I will move on to the next question. Question number 5. Does the new law that requires an HOA approve a charging station for EVs apply only to condominiums and not to single-family residences that have a garage? The answer is no. The new EV charging statute, which is RCW 6490-513, applies to all types of community associations today. So this applies whether you live in a condominium or a single family lot. And the statute prohibits associations from banning owner installed EV chargers in designated parking spaces or private lots. So garages in single family lots, as long as they are reasonable to install. And the statute does not require approval because it can set reasonable restrictions and conditions. And some of those conditions and restrictions are safety and code compliance. The chargers should meet building and all city codes. And you can set aesthetic standards and you could require insurance. But most of these conditions and restrictions should not matter for single-family home communities with garages inside the lots. And that's because those homes probably have separate electric service from the public utility and separate insurance for the entire building structure. But lastly, if EV chargers inside individual homes would actually impact the community or the neighbors, we recommend that you have your association attorney draft a EV charging policy for adoption, and this should be shared with all of the owners. And that way your owners have a common understanding of their responsibilities. Tima, Ken, would you like to add anything?
Yeah, for the most part, because the public utility is providing electricity to the single family home and all of the, breakers and protection of equipment is inside the home, there would be no reason for the association to care. I have had a couple of clients who were concerned about fires being started by the electric batteries or about the electrical grid becoming overwhelmed by too many EVs being used at the same time. But I'd say for the most part, the capacity of the system is a utility problem. It's not a problem for the community. I have had a couple of townhouse communities that were concerned because they had a transformer from the public utility, which was the association's responsibility. And that was something which, if it needed to be increased in capacity, the association would have to incur a charge. So they were trying to evaluate how much additional usage the EVs might have on the community to allocate that cost. Next question. For the last 14 years, our HOA has managed violations based only on complaints. This has led to uneven enforcement and a decline in the neighborhood. We're now considering allowing the Architectural Control Committee to do quarterly inspections. Do we need to announce this to the owners in the same way that we would do it if we were adopting new rules? Or can we simply vote as a board that we're going to start doing this and announce it to the community? So I would want to see what your particular CC&Rs or declaration says to understand what authority the ACC or the board has related to inspection and enforcement. And your rules and procedures would have to comply. I'd certainly recommend that you be upfront with the owners and tell them if you're going to start inspecting and enforcing, because you don't want this to be a surprise to them. You'd like them to know that, if you're going to start enforcing the lawn care rules, that they should know that you're going to enforce them before you go out and do the inspection. So announcing to the ownership in the same way you would a rule is probably effective. Again, I'd want to see what your particular documents say. The board could certainly vote to authorize inspections, but again, it depends on whether they have the authority to do those inspections. So under WUCIOA, which is the statute that will apply to all homeowner associations in about a year and a half, there is the power to inspect built into 649440 for components, physical components that might cause damage to the common elements or other units. I don't know that what you're inspecting would fall under that category. Under 649405, which is the powers of an association, boards have the ability to enforce the governing documents. After notice and an opportunity to be heard, they can impose a fine. So there is at least some implied authority in the statute to allow you to enforce the governing documents. So if the governing documents required owners to maintain their lawns, then the association would have the authority to observe the lawns and find violations and enforce if they chose to do so under that statute. Quarterly inspections might be reasonable and permitted if the governing documents provide for that. There's certainly a chance that if you wanted to do that, you'd have to amend your documents to give the board or an ACC that authority. And if you amended the documents, you would, of course, have to get a vote and then notify all the owners when it was approved. Before you made a change like this, it might be reasonable to have an association attorney look at your governing documents and figure out whether or not you have the authority before you decide to just start doing inspections and sending violation notices. But I'd also suggest that if you're doing something new like this, that you be giving warnings and maybe more than your standard policy, so that people have an opportunity to learn about the sort of regime change and how you're trying to enhance the quality of the neighborhood by enforcing your existing CC&Rs. Anything you want to add, Diana or Tima?
No.
No, that covers it. Question number 7. I write regular newsletters for the HOA. The newsletter draft goes back and forth to board members by email for suggestions and edits. Does the final newsletter have to be approved in an open meeting? It seems that this could be ministerial and could be approved by email. So my answer to the question is probably not, with the caveat being that the newsletter is only communicating general community-related information and not conveying any board, quote unquote, board decisions that were made outside of an open board meeting, in which case that would be invalid and a miscommunication. The definition of what is a ministerial act is still undefined. So we don't have I can't answer the question as to whether or not it's ministerial. But I would say that the risk associated with the contents of the newsletter may vary with what exactly you're saying. So again, assuming you're only communicating general information that pertains to the community as a whole, not any specific board decisions or actions being made by the board, I don't believe that you would need to have the newsletter approved in an open meeting. Ken, Diana, can you think of anything to add?
No, I'm okay with that answer.
Okay, I will move on to the next question. Question 8 says, our bylaws say that our annual meetings are to be held in person. The location where we have these meetings do not provide us access to the internet. It looks like the meetings are held at an elementary school. Are we required to offer virtual attendance as well? The answer is no. Offering a virtual attendance option is not a requirement. And this is true even if your governing documents expressly prohibit virtual meetings, because the statute says you may hold the meeting electronically, not that you must. And that statute is RCW 6490-445, section 3, which specifically says, notwithstanding the governing documents, so despite or in spite of your governing documents, any meeting may be held by telephonic, video, or other conferencing process. And that section lists out some requirements. One being the meeting notice states the conferencing process to be used and provides information explaining how to participate in the conference. And the process provides all participants the opportunity to hear or perceive the discussion and to comment as provided in subsection 2E of the section. So what this means is if your annual meetings are held on Zoom or some virtual platform, you must follow the requirements of RCW 6490-445, subsection 3. And one requirement is a call-in telephone option along with a Zoom link. And usually Zoom will generate a call-in option automatically, but you want to double check this. And if your annual meetings are in person, there's no need to provide a Zoom or a virtual option. It's not a requirement. Tima, Ken, would you like to add anything?
Well, I'd offer sort of stated differently is even if your bylaws say you have to hold an in-person meeting, the statute says you can hold the meetings over the computer and you don't have to have a physical location at the elementary school. So,
Okay, question number 9. Can a board member vote if they are not present at the meeting? So the answer to that is no. Board members may not vote by proxy under any circumstances. Under 6490-445-2, Section K specifically states a board member may not vote by proxy or absentee ballot. This applies to all communities of all kinds whenever they were formed. Proxy voting, and to clarify, proxy voting statutes only apply to owners. This is because boards are intended to act as a whole, and those that authority cannot be delegated. So that's the reasoning behind it. So the answer is no. I don't think there's anything further to add there, but Ken or Diana may have additional thoughts on that.
no, I think it's a short answer.
Yep.
Next
Don't do
question.
it.
When our restated CC&Rs are recorded, do we have the obligation as a board to update all homeowners with a copy of the restated CC&Rs? So I would say yes, you need to at least give notice that the documents have been recorded. If you've already sent a copy of the document that's to be recorded, that may be good enough. So part B is, can we send to those homeowners that have signed the form allowing for electronic notice a email copy of the restatement? The answer is yes, because they've agreed to receive notice electronically. But that only works if they have agreed to receive notice electronically. If they've not, part C, if they've not opted into email, can we email them as a one-time event? You can email them as a one-time event, but it will not qualify as notice under the statute. There is no one-time event exception in the statute. Section D, Those that have no email, do we have to mail them the restated CC&Rs? Yes, or you can hand deliver them as provided for in the statute. And then they're asking if we have this in our prior Wednesday videos, and I don't think that we do. So this would be the first time we've addressed that specifically. So Tima or Diana, do you have anything to add?
No.
Nope, nothing to add.
Okay. Question number 11. I have a question about a request that has come up in one of the associations we manage. The association does not want management to send monthly account statements to their delinquent owners. Other than the requirements timing for the pre-foreclosure notices, is there a downside, any downside, to an association not sending ongoing monthly account statements if there have not been any new charges or late fees added to the account balance? So I guess I don't like to answer a question with a question, but I think what I'll first say here is it is relevant to know what the reason is why the association doesn't want to send monthly account statements. I don't have that here, but I'm presuming it has to do with some sort of concern about expenses, the client's concerned about expenses. So in any case, our answer is going to differ depending on if we're talking about annual dues or monthly dues, also or quarterly dues, for example, and exactly how much the dues are relative to the cost of sending the notices. The cost benefit analysis, again, we go back to this test of reasonableness. For example, we talked earlier about the WUCIOA requirements effective January 26th until the first notice is sent during that 15-day wait period. You cannot collect late fees and interest, etc., apart from what we've already covered earlier, that initial $10, the $50 or 5% that's less, and the actual mailing costs. That being said, boards are allowed to balance the cost and benefit of actions taken, which may include the cost of sending monthly statements either to the HOA or to individual owners against the benefit that they get from that. So what are the benefits of sending notices? Well, you're asking if there's a downside. Well, let's start with the positives. Sending notices to owners provides transparency. It provides clarity in terms of when and what is owed. There's typically in a notice, there's an amount owed and a deadline for paying it. Ken talked earlier about the open meeting requirements about authorizing foreclosure lawsuits and the transparency that the legislature is aiming for here. Clearly, sending monthly statements to owners creates transparency. They can't later say that they didn't know. Now, I will add a caveat here because I'm a collection attorney. And so one thing that stands out to me here, if my client, a client has sent an account to collections, at that point, once an account is in collections with an attorney, we do not want you sending additional delinquency notices to the owners. After the file's been referred to us, the demand has been sent. At that point, the ledger is in the hands of your collection attorney, and the client should not be sending further delinquency notices to avoid what I call mixed messaging, confusion as to who's collecting the balance, what is owed, and that's because when, for example, we take a file, we create our own ledger. Our ledger includes all the legal fees and expenses that are already accumulated and anticipated. Those may not be in your delinquency notices. In fact, they shouldn't be. We include all interest and late fees that can be added to the ledger that are permitted by your governing documents. And the owner ledger balance changes daily once you're in a collection, once that file's been referred to collections. So that would be a caveat. Now, What are the downsides? Well, we talked about the upsides. So the downsides are the opposite. There are downsides to not sending a monthly account statement, lack of transparency, and potential confusion on the part of the owner as to whether or not they owe money and how much they owe and who they owe it to. That answers the question the way it was asked without more information. That's the best way that I can answer it. Diana, did you have any additional thoughts?
Well, my thought is that it's really important now that the first notice of a delinquency, the pre-foreclosure notice, is sent out. And under the statute, that has to be sent out within 30 days of the missed payment. It's not 30 days of your grace period. It's 30 days from when it was due. So I guess I don't have an opinion about monthly statements following that first notice, but you need to make sure you've gotten that first notice out, or you can't collect any late fees, interest, or other expenses until you've sent that out again. So if you're, not sending out the first notice, you may be eliminating the ability to recover most of your punishment, as it were, to try and get people an incentive to pay their dues.
Correct.
Next question. Does the annual assessment in RCW 649530 include special assessments? So this statute is the one which requires that an association perform a CPA audit if their budget is over $100,000. It used to be $50,000. It was just changed last week to a threshold of $100,000. And our answer is the probably. So even though the statute does specifically state annual assessment, I think if you were intentionally lowering your annual budget to under $100,000 and then also adopting a special assessment to pick up the additional money you need for the sole purpose of avoiding this audit, that you'd be found to be acting in bad faith and attempting to avoid a clear legislative intent that the associations have audits done. Okay. So special assessments are assessments the same as everything else, like late fees and regular dues. They are not technically part of the annual assessment. So I guess I'd probably be able to look at all the facts. If you normally had assessments that were under $100,000 and you had a one-time event that was not going to repeat, then I could probably suggest you get away with calling it not part of the annual assessment. But if this is just a way to try and manipulate your books to make it appear that you don't have a need to do a CPA audit, I would suggest you just spend the money on the CPA audit. Anything you want to add, Timo or Diana?
No.
Nope, nothing for me.
Question 13. Is the new Fannie Mae Freddie Mac reserve funding guidelines, do they apply to condominiums only? So the new, I think I'm assuming you're referring to the rule that was implemented after the 2021 condominium collapse in Florida. And that tragedy spurred a tremendous amount of scrutiny on specifically condominiums and their maintenance and various issues that resulted in this collapse. And the Freddie Mac, Fannie Mae guidelines are intended to create more, to provide scrutiny and safety around loans that are applied for by owners in terms of purchasing a unit. So the rule only these rules do not apply to HOAs, to answer your question. They only apply to condominiums. And again, these rules only apply to someone who's applying, who is seeking a loan to purchase a property. The Fannie Mae and Freddie Mac guidelines are they're the biggest lenders out there, and they have created these structured guidelines as a protection for potential unit owners. And there's something called the Freddie Mac Guide, and that actually goes through all the rules and what exactly is required. So in the scenario where a potential owner buyer is purchasing a unit in a condominium in cash and doesn't require a loan, these rules aren't going to apply to them. But because most buyers are getting loans to purchase units, it is a valid question, and it does apply to condominiums only. Ken, did you have anything to add, Diana?
Well, I'll add that there are some HOAs that have significant capital assets that need to be funded. I've heard stories about a community down near Olympia that had to replace a bridge into their community at a cost of $5 million. And we've certainly seen HOAs that have had to deal with things like bulkheads along the waterfront. And the same logic where the banking industry wants to know that there's not any threat to the security of their borrowers would apply. So I'd suggest you still need to disclose a lack of reserve funding if that's happening. But that is the end of our submitted questions. Chelsea, did we have anything in the chat we should address?
There was one question in the chat. For reserve studies, are there any statutes that would allow a community of any size to opt out?
The statute doesn't require reserve studies if there are no significant assets. I don't remember exactly the wording, but significant assets are defined. I think they're defined for condos as not having any reserve components that cost more than 50% of your annual budget. And I think for HOAs, it's 75% of the annual budget. You'd have to look at the statute. It's in somewhere in the 6495-35 range of numbers.
545 subsection 2, and they say nominal reserve costs. And nominal reserve costs are defined in the statute under RCW 6490.010. I think it looks like subsection 35.
So what's the nominal value?
It is what you said. It's 50% of the annual budgeted expense of the association, but this is only for condominiums. And its nominal reserve costs are defined as less than 75% of annual budgeted expenses for the association for all other common interest communities. So for HOAs.
There may be an exception for 2 and 3 unit communities as well, but I can't remember that one for sure. Is that it, Chelsea?
What if any documents can the HOA require an owner to produce when an ESA/service animal is in their unit, or have the owner's tenant produce for an ESA/service animal?
So this is an issue where there was recently a significant change at the federal level in how the administration treats emotional support animals compared to service animals, which are typically dogs trained to provide a specific service. I think there's a memo came out in mid-May at the national level saying that the past practice of treating emotional support animals as necessary was being changed to treat the request for an animal the same as all other service animals as defined in the ADA. So this is now I'll say an open question. The opinion of the of HUD, the Housing Urban Development, may or may not affect state laws. For the most part, Washington doesn't have a specific law about emotional support animals and has relied on the previous HUD standard, which was that if a person had excuse me, had a disability and they had a healthcare provider state that the animal was assisting with the disability, then you were required to allow the animal to stay. There's the potential now that under the new standard that if the animal is not trained to perform a specific service related to the disability, that you do not have to accommodate it any longer. We think there's a risk associated with trying to kick out all of the cats and other emotional support animals. There's going to be, in my guess, a new industry that will pop up similar to the old one where you could register your service animal. Now there will be service providers who will write letters swearing that the dog or the cat has been trained to perform some kind of service in order to support the disability of the owner. So we don't know what the answer is. The old answer was you could require proof of a disability if it was not obvious, like the person's in a wheelchair. And you could require a statement from the healthcare professional that the animal was necessary to accommodate the disability. I don't know what the new rules are because it's not been long enough for a court to figure it out. And we've heard nothing from the Washington State Human Rights Commission and what their opinion is going to be. That's all I got.
All right. Can a board remove a board member via electronic voting? And how would that work if the board member should be allowed an opportunity to be heard?
Well, boards cannot remove board members with the exception of under WUCIOA, a delinquent board member can be removed from office or from their seat if they're delinquent. I think it's more than 60 days and have failed to cure the delinquency after being given notice, and they get 30 days to do the cure. If you're talking about holding a removal election of the full membership, can that be done by mail or email? The statute requires that a board member have an opportunity to be heard before the vote. So it may be possible to find a way that you could have the board member have their opportunity to be heard by the membership before the electronic vote or mail-in vote. I think you'd have to talk with an attorney and probably coordinate with the board member to try and figure out a process that would withstand review after the fact. I might suggest you just do an in-person meeting if that's your goal. Well, maybe we're done a little early today.
Yeah, I think that's all for the questions in the chat.
See anything new? Well, thank you all for being here today, and we'll see you next week.
Thank you, everyone.
Have a great day.